All right, so I guess I'm supposed to chase people in, or no, you're going to go chase people in. I'm just supposed to talk. All right, so my name's Chris Tabor, and before I introduce our next speaker, I was asked to say a few words about one of the recent additions to the services that we provide at Fair Mormon, and that's the Fair Mormon Support Forum. Now, the Fair Mormon Support Forum is designed for people who are experiencing a faith challenge, a faith crisis, and those family members of the same group of people. And it's designed around the fact that one of the largest challenges that people in the midst of a faith crisis have is that they feel stuck in between not wanting to damage the faith of others that they love that are near them, but also not knowing who they can turn to with answers that they will trust. And so the Fair Mormon Support Forum was designed with that fact in mind, to provide a safe place to come and to ask questions in a faithful space, to hear from people who have been through a similar experience themselves, or have had family members who have had similar experiences, and to ask those questions and get that response in a safe community type of a setting. If you have questions about the Fair Mormon Support Forums, would like to learn more, you can check us out on the web at fairmormonsupport.org. Now it gives me great pleasure to introduce our next speaker, my friend Hannah Smith. Hannah grew up in Northern California and then attended Princeton University, where she received a degree from the Woodrow Wilson School of International and Public Affairs. After graduation, she served a French-speaking mission to Switzerland and France. And when she returned, she married John Smith, a classmate from Princeton who had joined the church after their junior year, and then later served a mission to the Ukraine. From there, both Hannah and John went to BYU Law School before becoming the first husband-wife couple to clerk for the same U.S. Circuit Court judge, a judge by the name of Samuel Alito. Next, Hannah spent her next year clerking on the U.S. Supreme Court for Justice Clarence Thomas. She later returned to the High Court when her old boss nominated her, or was nominated to fill the seat once held by Justice Sandra Day O'Connor. And then Justice Alito asked her to fill out the remainder of that term as one of his clerks. When she left the Supreme Court for the second time, and I don't know if they keep statistics on this sort of thing, but I imagine that the cohort of clerks who have clerked for more than one of the Supreme Court justices, given that there are 9, is fairly small. So she's probably in select company doubly. She was invited to join the Beckett Fund for Religious Liberty, a nonprofit special interest law firm that specializes in religious liberty cases, where she now serves as senior counsel. Most recently, Hannah was part of the team that represented Hobby Lobby in the much-discussed Burwell versus Hobby Lobby case. In the church, Hannah served as a gospel doctrine teacher, seminary teacher, stake CES administrator, and young women's leader. She and her husband, John, have 4 children and have recently moved back from Dallas to the Washington, D.C. area. She's also an accomplished musician, at one point serving as music director of the Princeton Tiger Lilies, which is the oldest all-female a cappella singing group on campus. And on a personal note, I first met Hannah a little over 21 years ago when I was about to start my freshman year in college, and I got a knock on the door, and here I am all the way across the country from where I grew up in California, and it's Hannah and some other LDS students. And I was kind of surprised at how they found out that I was there. I hadn't told anybody that I was LDS. My roommate didn't even know I was LDS. And that was actually because I was in a period of ambivalence, not doubt or struggle. I was just in a period of ambivalence toward the church. And it was actually through the friendship of Hannah and some of the other students there, LDS students, that I was able to find the examples that I needed to put my life, give me just the push that I needed to head in the right direction. And even if Hannah had not gone on to do all the amazing things that she has done, I'd be grateful to her for her example of discipleship at a critical period in my life. Please join me now in welcoming my friend Hannah Smith.
Well, Chris is very humble because he's also an amazing musician himself, and he was in another a cappella singing group at Princeton known as the Footnotes. And at Princeton there are these beautiful Gothic arches, and a long, long time ago, students thought that they had a pretty good acoustical reverberation. And so a cappella singing groups began the tradition of singing in the arches, and thus the arch sing tradition was born. And so Chris, when he sang in the Footnotes and when I sang in the Tiger Lilies, spent a lot of fun evenings under the Gothic arches at Princeton, singing some fun songs and enjoying friendship together. And my husband and I are very blessed by Chris's friendship. So I appreciate that very generous introduction. And it's really an honor to be here with you today. It's been 2 years now that FAIR has been asking me every year to come and speak, and for a variety of reasons I've had scheduling conflicts that have not permitted me to come. But I'm very pleased to be with you here today, and I'm delighted to be talking about this subject, which is near and dear to my heart. So I'd like to talk to you today a little bit about what Latter-day Saints need to know about our first freedom, religious liberty. And I'd like to begin with a bit of doctrine. But we don't have time to talk too much about all of the doctrine on religious freedom. I'd like to move then into some apostolic calls by several members of our church leadership on this subject, and then go into a survey of several prominent areas of concern right now, largely through the lens of litigation, which is what the Becket Fund does, but also to familiarize you as a Latter-day Saint audience in the various areas that are cause for concern in the battle for religious liberty. I think often as Latter-day Saints we think first and foremost about the issue of same-sex marriage and the conflicting interests for religious liberty in that specific area. But the battle for religious freedom is so much broader than that. And I hope today to be able to discuss some of these other areas and sort of round out your understanding of where these key areas are. So the Latter-day Saints' commitment to fight for religious freedom for people of all faiths actually began in our beginning. The prophet Joseph Smith said, "The saints can testify whether I am willing to lay down my life for my brethren. If it has been demonstrated that I have been willing to die for a Mormon, I am bold to declare before heaven that I am just as ready to die in defending the rights of a Presbyterian, a Baptist, or a good man of any other denomination. For the same principle which would trample upon the rights of the Latter-day Saints would trample upon the rights of the Roman Catholics or of any other denomination who may be unpopular and too weak to defend themselves." Indeed, the prophet Joseph Smith thought that this doctrine was so central that he included it in the Articles of Faith, and it was the subject of a revelation in the Doctrine and Covenants. So obviously, Article of Faith 11 talks about claiming the privilege of worshiping the Almighty God according to the dictates of our own conscience and allowing all men the same privilege. And then, of course, Doctrine and Covenants 134, which also talks about rights of conscience and the importance of protecting the sphere of conscience for everyone. And in our day, we've had several leaders in our church issue apostolic calls on the issue of religious freedom. And the Public Affairs Department has done a wonderful job of building networks with faith leaders, creating online resources, promoting religious freedom. I would encourage all of you when you go home to go to the Mormon Newsroom .org, where there is a collection on their religious freedom page of some really high quality materials, including video documentaries, one called What is Freedom of Religion, some Mormon messages, print materials educating members on these issues. There's even now a Facebook page called Supporting Religious Freedom, which you should definitely like and follow. And there's a comprehensive collection of all the General Conference talks that touch on this area. And just to highlight two of those, I want to focus on a talk that Elder Cook gave at BYU Idaho Commencement in 2011, where he talked about the rising generation and the need for them to make their voices heard in defense of religious freedom. And he said, one of the reasons the attack on moral and religious principles has been so successful is the reluctance of people of faith to express their views. Extraordinary effort will be required to protect religious liberty. Our doctrine confirms what the U.S. founding fathers and political philosophers have advocated. And then Elder Oaks, of course, given his background in the law, has given several wonderful addresses on the topic of religious freedom. One of them was at Chapman University in California, also in 2011, where he called on Latter-day Saints to unite with like-minded groups in this fight. He said, "It is imperative that those of us who believe in God and in the reality of right and wrong unite more effectively to protect our religious freedoms. All that is necessary for unity and a broad coalition along the lines I am suggesting is a common belief that there is right and wrong in human behavior that has been established by a supreme being. All who believe in that should unite more effectively to preserve and to strengthen the freedom to advocate and practice our religious beliefs, whatever they are. We must walk together for a ways on the same path in order to secure our freedom to pursue our separate ways when that is necessary according to our own belief." So I have the great fortune of working at the Becket Fund, which is a nonprofit, nonpartisan, public interest law firm. It was founded in 1994 by a devout Catholic, Kevin Seamus Hassan. We are very committed to the principle of defending religious liberty for all people. We believe it's a God-given right, and that in order to protect ourselves, we have to protect others, because if we don't protect others, the next person who will be persecuted is likely our own faith. We do this in three areas of concern: in the courts of law, where we litigate precedent-setting cases, and in the field of public opinion, where we appear on national TV outlets, and then also in the academy. We've actually established recently a religious liberty clinic in Stanford at the law school there, where students now have an opportunity to participate in religious liberty cases while they're going through law school. So what are these pressing religious liberty issues that we're facing today? What are the cases that we're litigating that are attempting to push back these threats? There's several patterns of different cases that I'd like to talk about. The first one is the HHS Contraception Mandate. You've likely heard about the Supreme Court case dealing with Hobby Lobby, and I'd like to start first with that area. The Becket Fund was actually the first law firm to file a case challenging this mandate, and the mandate was actually issued by the U.S. Department of Health and Human Services under the new health care law, and it required all employers, including religious objectors, to pay for contraceptives, sterilization, and what they believe to be abortion-inducing so-called emergency contraceptives. That includes drugs like Plan B, the morning after pill, and Ella, the week after pill, and several IUDs that certain Christian faiths believe cause an early abortion. They prevent the implantation of a fertilized egg, and because of their belief in life at the moment of conception, believe that those are abortifacient drugs. So under this mandate, there's actually a very narrow exemption for churches, but only churches, simply houses of worship. And there are many religious organizations, including colleges, universities, schools, hospitals, charitable organizations that are religiously oriented, that don't qualify for an exemption from this mandate. And so if a religious organization does not comply, then they'll be issued crippling fines that will be designed to force them into compliance. And the administration actually gave somewhat of a grace period to nonprofit religious ministries, delaying the enforcement of the mandate towards them. And under this accommodation, they would purport to shift the responsibility from the religious entity onto its insurance company, which is somewhat of an economic fiction, where the religious institution would still bear the costs under higher premiums. So this so-called compromise that the government has issued towards these nonprofits has been not well received, to say the least, by many of these nonprofit religious organizations. And so while there was a reprieve for the nonprofits, the government felt that there was no need to provide an accommodation of any sort for-profit businesses that were run by families who had religious faith or religious beliefs at the center of their business. So the for-profit businesses, actually, those cases developed earlier in the litigation stream, if you will. And that is why the Hobby Lobby case, which involved a for-profit entity, the Green family ran this closely held family business, Hobby Lobby. That is why that case went to the Supreme Court first, because they did not receive any accommodation from the government. So there's currently about 100 lawsuits filed by religious nonprofits around the country that are still challenging the legality of this mandate. But we brought the Hobby Lobby case to the Supreme Court this last term. And along with another case called Conestoga Woods, which was a case from Pennsylvania, those two cases, Hobby Lobby and Conestoga Woods, were consolidated and heard before the Supreme Court this last term, argued in March by the former Solicitor General Paul Clement. And the case was decided on the last day of the Supreme Court term this summer, June 30th. And as you may have read, the Supreme Court ruled in favor of Hobby Lobby. It was a challenge under the Religious Freedom Restoration Act. This was not a constitutional challenge under the First Amendment. It was under a federal civil rights statute that was passed about 20 years ago with bipartisan support. Both Republicans and Democrats came together, crossed the aisle to pass almost unanimously. There was only, I think, 3 dissenting votes in the Senate for RFRA. Passed this federal civil rights statute that protected the rights of religious persons against substantial burdens by the federal government. So here the question was before the court, well, is this for-profit business a person that is protected by the Religious Freedom Restoration Act? And the court, in a 5-2 decision on this first question, left no doubt that private, for-profit, closely held businesses like Hobby Lobby are protected under the Religious Freedom Restoration Act. Now you ask, why 5-2? I thought there were 9 members of the Supreme Court. Well, 2 members of the court, Justice Breyer and Justice Kagan, did not answer that question. They said, we don't need to answer that question. So that's why it was only 5-2. Only Justices Ginsburg and Sotomayor dissented on this point. So the act applies, RFRA applies to for-profit businesses. So did it burden Hobby Lobby here? And on the merits, the court held 5-4, with Justice Kennedy being the deciding vote, that yes, the HHS mandate did violate RFRA's terms as it applies to closely held family businesses. And specifically, they said, this threat of fining these businesses millions and millions of dollars if they don't comply, that is surely a substantial burden on religious exercise. The opinion said, if these consequences do not amount to a substantial burden, it's hard to see what would. And then they went on to say, okay, there's a burden here. Now, has the government shown that they have a compelling governmental interest, or is there a less restrictive means of accomplishing this interest? And that's what the government had to prove. And the court said, no, they haven't proved that. There are less restrictive ways of accomplishing this goal of providing contraceptives through insurance. And the opinion said, quite frankly, the government could pay for it itself. It doesn't have to force religious objectors to do so. And so that is the decision in Hobby Lobby. It was a great victory for the Green family, for Hobby Lobby, for all closely held family businesses that strive to run their business according to their religious beliefs. Now, you might ask, well, what about these nonprofit religious ministries that are still challenging this mandate? What does Hobby Lobby mean for them? And here, the Little Sisters of the Poor is one of those cases. The Little Sisters of the Poor is an order of nuns, and they care for the elderly poor. And they are still challenging this mandate in the lower courts. We also represent another client called the Eternal Word Television Network, which is a Catholic media network founded by a cloistered nun. And we also represent another organization called Wheaton College. You may have heard of them. They're an evangelical college, and they continue to defend against this mandate in court. And earlier this year, the Supreme Court actually said, remember that accommodation I talked about Well, the government said, if you just sign a form that authorizes your insurance company or your third-party administrator to provide these objected drugs and devices on your behalf, you just sign a form, you tell them to do it, then you'll be released from your obligation. Well, several of the religious nonprofits can't accept that accommodation because signing the form to them would still be complicity with evil and engaging in an action that would be endorsing that wrong. And so the Supreme Court earlier this year actually gave extraordinary relief. I clerked at the court twice, and requests under the All Writs Act are extremely rare. They're extremely rare to be granted. But the court actually has granted it now twice in this litigation. Once on behalf of the Little Sisters of the Poor, they said, you don't have to sign that form. Since you believe that that is complicity in evil, you don't have to sign that form. They also granted the same relief to Wheaton College just 3 days after the Hobby Lobby decision. So now the government is going back, reworking its accommodation, figuring out what it's going to do. And as they do so, there are 100 cases still pending related to the mandate in the lower courts. So let's move on to the next topic, which is religious autonomy. The second area of concern is the effort by some to restrict the freedom of churches and faith-based associations to organize and choose their own leaders based on religious criteria free from government intrusion. And you may recall 2 years ago there was a really important case at the Supreme Court called Hosanna-Tabor Evangelical Lutheran Church and School. We also represented Hosanna-Tabor at the Supreme Court, along with Doug Laycock, who's a professor at UVA Law School. And the issue in that case was about the ministerial exception. What does that mean? Well, for 40 years, all of the federal courts of appeals and many state Supreme Courts had recognized the existence of this ministerial exception, which was this constitutionally based rule that exempted certain religiously based employment decisions from the reach of certain employment laws. So in Hosanna-Tabor, the Justice Department actually argued at the Supreme Court that the ministerial exception should not exist at all, that there were no special protections in the Constitution and the First Amendment that protected this very special relationship between churches and their ministers. This was a head-on attack challenging the very existence of religious autonomy in the hiring and firing of ministerial employees. So during the oral argument in that case, I was actually there for the oral argument, and several of the justices, even Justice Kagan, who was appointed by the current administration, found that position so remarkable that she said so in oral argument. And when the opinion came out, it was a 9-0 opinion, a unanimous opinion by the Supreme Court rejecting that position as extreme, remarkable, and untenable, and simply not the way the First Amendment works. And instead, the court confirmed that there's this ministerial exception that protects very broadly the right of churches to choose their leaders free from intervention. So if we won in Hosanna-Tabor, then why is this still an area of concern? And the reason is there's another Supreme Court case called Christian Legal Society v. Martinez. And that was a case that didn't turn out so well in the Supreme Court several years earlier. And it actually upheld something called an all-comers policy at a publicly funded law school out in California, Hastings, that required student groups to accept anyone into their group's membership and leadership ranks. So if you were a Catholic student organization, you had to accept an atheist into your membership, and you even had to accept an atheist as your president of your group. The administrations at various state-funded and even private universities that aren't specifically bound by this ruling even are now using this decision to create and enforce policies that require religious student organizations to allow students who don't adhere to their beliefs to become leaders in their student groups. And so these policies, specifically I read a news article about Vanderbilt, where they're driving religious student groups off campus. They're simply not requesting official recognition anymore on campus because of these policies. So they're pushing religious groups into away from campus and off campus or into extinction. So that's a real area of concern for those who believe in the vibrancy of freedom of association, particularly free religious association. The third area of concern is religious land use. Many Latter-day Saints are familiar with this area because we're familiar with the church's struggle sometimes to get temples built in various areas around the world, and perhaps to get even spires of a certain height or angel Moroni's on top of those spires. But it's an area that affects many different religious faiths. We represented the Islamic Center of Murfreesboro in Tennessee, and this particular community of Muslims had been part of this community for about 30 years. But in 2010, when they sought to build a new mosque to accommodate their larger numbers, their efforts were met with very hostile protests from a small group of local residents who claimed that this congregation was threatening simply because they were Muslim. And this hostility actually culminated in several acts of vandalism. You can see on this sign here, it says, "Not welcome." There was even some arson and a bomb threat, which resulted in a federal indictment. So the opposition eventually reached the courts, as these cases often do, and those who opposed the mosque filed a state court lawsuit. And the land use process often involves, county planning commissions, local planning commissions, where they have to approve, the various plans and such. Well, even though the County Planning Commission approved this new mosque at a regular meeting with regular public notice, the state court judge held that that regular notice was not sufficient in this case. Because of the quote-unquote tremendous public interest surrounding the mosque, the judge decided that the county commission's approval process should have met a heightened legal standard. Well, the Becket Fund filed a federal lawsuit, not in the state courts, but in the federal courts, and we were actually joined by the Department of Justice in this case, and requesting that the community be permitted to complete the building permit approval process. And we argued that applying this tougher legal standard than all of the Christian churches had applied to them when they applied in previous years, that violated the Constitution. And the federal judge agreed. And they ordered that the mosque needed to be finished, and indeed it was, in time for celebration of Ramadan. The next area that I'd like to talk just briefly about is, again, dealing with conscience rights, specifically those related to pharmacists that feel an objection to dispensing drugs that violate their religious convictions. And again, this involves the abortifacient drugs that are involved with the HHS mandate, Plan B, Ella, those kinds of drugs that involve abortion. And here we actually represent two different cases, one in Illinois and one in Washington state, challenging state regulations that would require these religious pharmacists to stock and dispense Plan B and Ella, even when doing so would violate their religious convictions. So in Washington, it's a really interesting case where the State Board of Pharmacy, and oftentimes there are these accrediting bodies or these professional organizations that monitor the professional activities of the members of their group or their trade. So there's this State Board of Pharmacy, which initially supported a rule that protected conscience for pharmacy workers and permitted them to, if they had a religious objection, they could refer those customers to other nearby pharmacies. So they could say, well, I can't dispense this drug to you, but here's a local pharmacy just down the road. Go to them. They will have it for you. But under pressure from the Washington state governor, the Board of Pharmacy reversed course. And even though the board admitted that there was no evidence at all, and this is what's so significant, there was no evidence that there had been any patient that had been denied receiving medication due to the religious objection of a pharmacist. They issued a regulation that required these pharmacists to stock and dispense these drugs. So there was really no problem they were solving. They simply wanted to strip the conscience protection away from these pharmacists. So two religious pharmacists sued. They were basically forced into a position of choosing between their faith and their profession. One pharmacist had already lost her job, and the other one was threatened with losing her job. And in the end, we were successful in persuading the trial court to find the Washington state regulations unconstitutional. And those were appealed. That decision was appealed up to the Ninth Circuit, and we're still representing those parties in the Ninth Circuit. But in the Illinois case, we actually were successful in having those definitively struck down, and there was no appeal in that case. The next category is redefinition of anti-discrimination laws. This you're probably more familiar with. It involves state court decisions and new state statutes that redefine anti-discrimination laws to prohibit discrimination on the basis of sexual conduct, but lack sufficient corresponding protections for religious freedom. So, for example, you may have read in the news, Massachusetts, Illinois, District of Columbia, faith-based adoption agencies that have had to stop placing children for adoption, and in some cases they've closed their doors altogether rather than capitulate to new legal requirements that violate their religious teaching on the family. So on the issue of same-sex marriage, the Becket Fund does not take a position on the issue of same-sex marriage per se, but we do take a position on the religious exemptions that should be built into these laws to protect and to provide a robust enough protection for religious people. So in December of 2005, we actually convened a conference with noted First Amendment scholars representing the full spectrum of views on same-sex marriage. There were professors there who advocated for same-sex marriage and those who didn't, but they all agreed that there would be inevitable conflicts between same-sex marriage and religious freedom. And indeed, we're seeing those conflicts now come to pass. You've probably read in the news about religious photographers, for example, who declined to photograph same-sex commitment ceremonies, or bakers or bed and breakfasts who would decline to be involved in these kinds of very sacred ordinances that, according to their religious beliefs, they object to. And so this conference resulted in this book, Same-Sex Marriage and Religious Liberty, Emerging Conflicts, which is available on Amazon if you have any interest in it. It's a really wonderful scholarly approach to the subject, and it remains to this day the foremost book out there on this subject. Finally, religion in the public square. This is something that I think all of you have probably read about in the papers. Various atheist groups and the American Humanist Association and other groups that go around the country and find public displays of religion that they object to and then bring a lawsuit over them. And there are many examples of this. There are those who would strip the words "under God" out of the Pledge of Allegiance simply because they're religious. There are those who would discontinue our nation's long tradition in legislative prayer. Indeed, there was a case at the Supreme Court this last term, Town of Greece v. Galloway, which dealt with this issue of legislative prayer and upheld the practice due to our nation's long history of legislative prayer in various contexts. And there are other cases that involve just removing religious symbols, whether they be roadside crosses or statues of Christ that are upheld as veterans' memorials for various wars. So there are a variety of different ways that this concern shows itself. But we have been very active, particularly in the cases involving the Pledge of Allegiance. We actually have defended the words "under God" and the pledge now in about 3 different states, from California to New Hampshire to Massachusetts, and then just this summer we have moved to intervene in a case in New Jersey. And in the California case, it was a really interesting situation where we successfully argued before the Ninth Circuit that the phrase "under God" in the Pledge of Allegiance actually affirms a foundational political premise in the American tradition of law and rights, namely that human rights are not bestowed by the state, but are rather derived from a source beyond the state's discretion. And thus, the words "under God" do not unconstitutionally advance religion, but rather reflect the deeply rooted political philosophy of the Founding Fathers, who believed that those rights derived from a source greater than a government made of men. Now, originally, the Ninth Circuit had held that the words "under God" were unconstitutional, and then the case, because of some technical twists and turns came back, and we argued this, and the Ninth Circuit actually reversed itself, which is a phenomenal feat for one of the circuit courts of appeals that is deemed one of the more liberal in this country, to reverse itself and actually uphold the words under God in the Pledge of Allegiance. And we have continued to defend the pledge in New Hampshire successfully, in Massachusetts successfully, and now this summer we are intervening in this New Jersey case. And then finally, I'm just going to preview for you a case that's coming up in the Supreme Court this fall. On October 7th, we are going to be back in the Supreme Court arguing a case dealing with prisoners' religious rights. Again, we're going to be partnering with Doug Laycock of University of Virginia Law School, and this case involves another federal civil rights statute. RFRA was passed in 1993, and then 7 years later in 2000, again with great bipartisan support, both Republicans and Democrats came together to pass another federal civil rights statute called, it's a very funny name, Religious Land Use and Institutionalized Persons Act of 2000. Now you say to yourself, well, what do religious land use and institutionalized persons have anything to do with each other? And they don't. It was simply the way law is made in Washington. Conservatives were concerned about churches and the discrimination they faced in land use decisions, and liberals were concerned with religious discrimination in prisons. And so when they came together to pass this statute, those were the two subject matters that were joined together in harmony. And essentially, Senators Hatch and Kennedy said this in a joint statement that supported RLUIPA, as it's called, Religious Land Use and Institutionalized Persons Act. Whether from indifference, ignorance, bigotry, or lack of resources, some institutions restrict religious liberty in egregious and unnecessary ways. So Congress held hearings over 3 years and found that many prisons barred Jewish inmates from wearing yarmulkes. They denied Catholics access to the sacraments. They shut down evangelical Bible studies. They denied kosher food, and on and on. And so RLUIPA was passed to reinstate this very strict standard of strict scrutiny. Is there a compelling governmental interest? Do they use the least restrictive means when they burden the religious rights of prisoners? And so we have a case coming up in October, Holt v. Hobbs, which deals with a Muslim prisoner who has been denied the ability to grow a half-inch beard that his Muslim faith commands, even though Arkansas already allows inmates to grow beards for medical reasons, and even though a half-inch beard is permissible in over 40 states and the federal prison systems across the country. So 40-plus states and the federal prison systems would permit a half-inch beard, but Arkansas doesn't. And so he represented himself. This prisoner represented himself, wrote a handwritten petition to the Supreme Court. Justice Alito read it, thought there was merit to it, sent it to the entire court. The court granted the petition, and we are working with Doug Laycock in this case that's going to be argued on October 7th. It's going to be very significant in interpreting this federal civil rights statute, the Religious Land Use and Institutionalized Persons Act. So I'm low on my time, and I want to make sure that I leave room for questions, but I do want to just read this last quote from Michael Gerson, who was a speechwriter actually in the Bush administration at the same time that my husband John was serving in the White House counsel's office. And he wrote this in an opinion editorial that dealt with the HHS mandate, but I think that it really encapsulates very well the struggle that we have in our American society. So I want to end with this. Liberalism, back to John Locke, has understood religion to be a fundamentally private matter. It has a difficult time understanding the existence of loyalties outside the law, and often views them as dangerous, unless the demands of faith are harmless and picturesque like the Amish. But this is not the way many religious people understand religion. They view it as a grounding for a vision of justice and the source of standards for a community of believers. It has been part of the American miracle to balance individual rights with institutional religious freedom. And that's what we do at the Becket Fund. We defend religious free exercise. And I just wanted to close with this picture of my kids at a religious freedom rally in Dallas, Fort Worth, when we lived back there. These are 3 of the 4 reasons why I do what I do. My sweet Gladys and Lucy and George, and now we have a 4th, John Henry, who was just born earlier this year. And I know that this American miracle, as Michael Gerson put it, was the creation of an all-powerful and all-loving Heavenly Father. And I also know that we can be his hands here on earth to help protect and defend this cherished freedom. And I urge each and every one of you to think of the ways you can be involved in your community, to stand up for religious freedom, whether it's in your school board or in your library community committee, or whether it's in other ways. But find ways where you can get out and be involved in the community, to link arms with our brothers and sisters of other faiths, as Elder Oaks encouraged us to do, and to find ways to stand up in your own way for this, our first freedom. And I will now take questions. Oh yeah, I'm sure there are. Does it concern or frighten you that the Supreme Court decision on Hobby Lobby was 5-4? No, it doesn't. And I think the reason that you saw 5-4 rather than 9-0 is because the statute that we were litigating under, the Religious Freedom Restoration Act, is a balancing test. It says you balance the government interest with the religious interests in the case. And, different judges are going to find that balance weighs out differently. And indeed, the four more liberal justices found that the balance should be on the side of the government in that case. So I'm not surprised, but, at the Supreme Court, you only need 5 votes, and we got them. So. Could you comment on the possibility that the Bill of Rights might be amended judicially or legislatively to exclude religious liberty? I think that constitutional amendments are so difficult to accomplish. I don't think that there will be an amendment to the Bill of Rights. There have been some calls after Hobby Lobby to reform RFRA, because after all, there's sort of this dialogue between Congress and the courts, and Congress patches a statute, the courts interpret it, and if Congress doesn't like the court's interpretation, then Congress can go back and re-legislate and change things if they want to. So after Hobby Lobby, you saw a lot of fist pounding about, we need to change RFRA. Personally, I don't think those efforts are going to go very far, but that is the constitutional conversation that we have in our country in this system of separation of powers. Let's see. Yeah, there's a lot here. I'm sorry, I can't get to them all. How does the Becket Fund have standing to file cases, or do they always file as amicus? Very impressive that you knew amicus curiae. That's very impressive. So we file cases on behalf of clients. So when we see an issue that's significant, sometimes clients will come to us, sometimes we'll go out and see if there's a client who's interested, but we will represent them as their attorneys. And then other times we do file amicus briefs. Actually, we filed amicus briefs in almost every case involving religious liberty at the Supreme Court for the last 20 years that we've been in existence. So we do file a lot of amicus briefs, and for amicus briefs, we do still represent somebody, but we are not a party in the case. We just give legal arguments to the court to consider in their decision in the case. So that's how amicus is different from being a party in the case. Does the BYU Law School or the church through other means file amicus briefs or provide support in other cases where schools, municipal governments, the Boy Scouts, et cetera, are sued by the ACLU? So actually in Hosanna-Tabor, the case in 2012 that involved the ministerial exception, there was an amicus brief that was filed by the BYU Law School, Professor Cole Durham's group. The International Center for Law and Religion Studies filed an amicus brief. The church's attorneys, Curtin and McConkey in Salt Lake, are very active in supporting our efforts, and oftentimes will draft amicus briefs for particular parties, and the church will often join those amicus efforts. So yes, the LDS Church is involved in amicus efforts both as signers, signing on to amicus briefs, and also through the Curtin McConkey attorneys, who are very proficient at religious liberty issues, who draft some briefs for these cases. Let's see. Sorry, sometimes I can't read your handwriting very well. What might happen to temple marriages in Utah if gay marriage becomes totally legal here? So I think it's really important to recognize what's a problem and what's not a problem. And here, I don't ever think that we're going to get to the place where the government would step in and say you have to perform a same-sex marriage within the temple. That is something that is so sacred and so much at the heart of the religious practice of our faith that I don't think that that will ever happen. So I don't think that's something we need to be worried about. Let's see. Sister Smith, thank you for defending us. You're welcome. Okay. There's a lot of same-sex marriage cases. So the same-sex marriage cases are going to be taken up to the Supreme Court, currently in the process of filing a cert petition, which is the way that the Supreme Court selects cases. Supreme Court has about 10,000 cert petitions that are filed every year. If you can imagine, 10,000 petitions that the Supreme Court has to sift through. And they actually only ever decide about 80 cases on the merits. So there's only 80 cases that are argued and then decided at the Supreme Court. So that petition will be evaluated by the justices, and then if it's granted, we'll get oral argument and then go through the merits process. But you know, there's going to be some case in the near future that deals with this issue because it's such a substantial issue of national import that I'm sure the Supreme Court will grant one of those cases. It's just not clear which one, and they have to evaluate which one is the best, we call it the best vehicle to evaluate the issues in the case. Lots of Utah same-sex marriage cases, questions. How far down the rabbit hole does the religious liberties of prisoners go? Can a Satanist sacrifice a chicken as part of his or her worship? So it's really important to remember that under the Religious Land Use and Institutionalized Persons Act, again, it's a balancing test. So is there a compelling governmental interest? And is that interest furthered by the least restrictive means? And in the prison context, there will always be a very compelling interest in security. And obviously, in those types of cases where you're dealing with, that kind of a practice, there would be a significant government interest in security. So you have to remember that there's always a balancing act going on here. In our case, a half-inch beard doesn't provide much of a security threat at all because the government argues in that case that you can hide things in a half-inch beard, and they've yet to provide any examples of what could be hidden in a half-inch beard. So there you see the government sort of providing a false interest, if you will, or an interest that's not well documented or evidenced. Okay, what is to prevent the Seventh-day Adventists from paying for blood transfusions? Is Hobby Lobby a slippery slope? So I got this question a lot when I was doing media after Hobby Lobby came down. And if you look at the majority opinion in Hobby Lobby, Justice Alito was very, very careful and in several pages went on to describe how limited the holding was in that case. He said this case only applies to the HHS mandate. It does not apply to blood transfusion cases. It does not apply to vaccination cases. It does not apply to discrimination, race discrimination cases. So he actually went down the list of some of these areas where people had said, well, this is a slippery slope and you're just going to provide a huge exemption for these kinds of religious practices. But he was very careful in drafting a very narrow opinion that specifically discounted those concerns. And again, it's a balancing test. So in the vaccination case, you could have a very compelling interest in the herd vaccination immunity. I think we're probably almost out of time, so. Okay. Okay, let's see. Let me see if there's one more I can take. these are all, I think, ones that I've already answered, so I think we're done. But thank you very much. You've been a wonderful audience today.
Thank you very much. Thank you.